Thank you, everyone. Please be seated. Our final argument for the morning is Hunter 3 Farms versus Hunter and others. And it looks like the parties are ready to proceed. Mr. Cady, and I'm not going to leave you guys out. Tell us where you went to high school.
Good morning, Your Honors. Spencer Cady, Fort Dodge Senior High School, home of the Dodgers. I know our fight song was vaguely referred to as the Dodger fight song. And that's the extent of my knowledge. May it please the court, counsel. This is a case that starts and ends with the plain and clear meaning of Iowa Code 489-4072. Under Iowa's LLC Act, LLCs are the product of statute, and the act provides that limited liability companies have the freedom to determine how they're governed through the use of operating agreements. What the rules provide, or the statutes provide in Section 409 are the default rules for LLCs when they don't have an operating agreement or when provisions of those operating agreements are at issue. At issue here is the default rule in Section 489-407-2D2 for managerial decisions. And that rule provides that an affirmative vote or consent of all members is required to undertake an act outside of the ordinary course of the company's activities. There's no mention and there's no reference in this statute to voting to being limited to only those disinterested members.
Where I stumble, and it's a different place than where the majority on the Court of Appeals stumbled. This strikes me as within the ordinary course of business. It's a suit for asking for a share of a $60,000 payment. And as I understand, these folks have thousands and thousands of acres of farmland. This is a huge operation, isn't it?
Yes, and Your Honor, we respectfully disagree with that position. Both the District Court and the Court of Appeals correctly found that the lawsuit that was filed by the LLC against Richard was not part of its ordinary activities. Contrary to what it's been characterized, Hunter 3 Farms LLC was not seeking any debt collection. This was not a suit to collect on an open account or to collect rent from a farm tenant. Hunter 3 Farms LLC's primary purpose was to market and sell a piece of property in Grimes. And while that property was for sale, they would farm it out. It's a 111-acre piece of parcel of land. Gary Hunter testified in the record that the ordinary course of the business was to find a tenant and to pay the bills. This action involves who is the rightful owner of a Syngenta corn seed settlement payout. This settlement dates back to well before the creation of Hunter Farms LLC and determines who's entitled to that settlement payout. Richard filed with Syngenta for what he believed was his share. After the parties entered into a global settlement, they split thousands of acres all to the third. Richard applied for his third. So this was an action that does not deal with the ordinary course of business for Hunter 3 Farms LLC, which
Size of Hunter 3 Farms, how big an entity is that?
In 2016, there's a global settlement, which the terms are in the record, the material terms are in the record, where the parties split their land in thirds. They had over 8,500 acres. Hunter 3 Farms LLC was formed to hold one particular parcel that's 111 acres. That's right off 141 in Grimes that is set for development land.
I want to ask you a question about the text. You keep saying the ordinary course of business, but the statute says the ordinary course of activities. Does that matter?
I think it's a slight distinction, and in this case, it has no bearing on the ultimate outcome of this case. It's Richard Hunter's position that the LLC actually had an operating agreement through its statement of authority, which described this particular piece of land, how this land should be sold, and that had language that was similar but not identical to Section 489-4072. But we concede for purpose of this argument that the district court and the Court of Appeals found that to be a factual issue and instead relied upon the default rules under 489, 4072.
The subsection D, when it defines kind of what's outside the ordinary course of activities, and it really looks at kind of financially significant transactions relating to what I'll call winding up the business or divesting it of most of its property. To me, this doesn't seem like in that category. So what should I infer from subsection D?
The subsects in section 489, 407 set forth those things that the legislature determined were so significant that under the default statute of the rule should require affirmative consent and approval from all members.
But don't those examples kind of help furnish our understanding of how to, kind of define this term?
Well, I think each of those sections are separate and apart. And the legislature's inclusion of the provision that says outside of the ordinary activities of the company is separate from the other sections in terms of winding up the business.
I just, I haven't taken corporate law in any form or really practiced it a lot since law school, but I always understood in the corporate law context, there were certain ordinary things that the board of directors or the officers of the company would do, and then you had extraordinary things that had to be submitted to a stockholder vote, like a merger or, and I thought that what this language was driving at are those extraordinary things, which this doesn't strike me as.
And I think there's a distinction between corporate acts, which has the board and has shareholders, and partnership acts versus an LLC, which is the hybrid of that form. And I think it's a two-layer assessment, and it's fact-specific with this particular case. But we talked about the Syngenta seed and how that's not part of the ordinary either sale of the property or the farming operations. But going a step further is that it's not just a suit regarding the Syngenta payout. What this is actually a breach of fiduciary duty suit against an own member of a company, which takes it in an additional layer outside of the ordinary course of activities of Hunter 3 Farms, LLC.
And that any litigation would be outside the ordinary course of activities and would require unanimity among all the members?
Position in this case, Your Honor, and I don't think that would be a good rule to have. There are situations where filing a lawsuit might be part of a company's ordinary course of business.
It's not. Let's assume this fact pattern. You're saying the purpose of the company is leasing farm ground, collecting rents. As I understood you, you said litigation is not part of their ordinary course of activities.
Right, and I think it could be in an instance. For example, if they needed to sue the tenant to collect payment that was owed. If there's an issue with a vendor in terms of inputs on the farm where they had to take action to collect money that they'd be owed under contract. In this case, it's a separate issue. This is filing a fiduciary duty claim against your own member for the rights to settlement proceeds that predate even the existence of this LLC and involve land that's not even included or part of this LLC.
Confused by. So 103 Farms is just 111 acres, but this $60,000 related to maybe all of this 8,500 acres or some of this 8,500 acres. Is that the argument?
Correct, Your Honor. There was a right to a class action settlement payout through Syngenta. It dated back to pre-existing Hunter 3 Farms. Hunter 3 Farms LLC was a product of a settlement where they divided most of the land but couldn't decide on what to do with 111 acres. So that was how Hunter 3 Farms LLC came about. And they didn't have a formal entitled document, said operating agreement.
103 Farms, and I apologize, maybe I should have been studying the record more. Did 103 Farms acquire the right to, in this settlement, among the brothers, to all of the Syngenta proceeds? Is that how it worked?
Settlement proceeds were not specifically spelled out or set forth in this settlement. It was a very extensive, complex settlement to divide up, the history of the brothers' farming operations for the 70s, and has actually generated other litigation throughout this dispute over time. So it was not set forth who was entitled to those rights. And so the basis of the facts of the underlying suit is that Richard Hunter believed he was entitled to the Syngenta settlement for his land that he has farmed, and so he applied for them personally, is what he understood he was doing. And that was the basis of this claim, is that the LLC now believes that it's the LLC's right to have the settlement.
Liability for the company, though, correct?
I wouldn't say it was a liability for the company. He submitted what he believed was an application for his acres, which predated the LLC, and he received that income. It's the other members who are saying, well, you didn't do that for us as well, and you breached a fiduciary duty by doing that. And by the way, the money that you did collect should be ours because it was part of the partnership that has since become the LLC.
That for tax liability purposes, this is going to be treated as income to the LLC.
The way that the payment was structured, and there's disputes on that, as to whether it was right or not, but the way that the settlement was structured did issue a 1099 to Hunter Farms, I'm sorry, and that's where this dispute arose.
Why this is not within the ordinary course of activities, because I don't like to read a provision in isolation. I think we need to consider related provisions, and we've got one that defines what is outside of that, and it's a big deal, like choosing to go into bankruptcy, selling all the assets, shutting things down, and this is nothing like that.
It has not been clear. There's been no definition of what's the ordinary activities or the ordinary course of business. But the facts alone in this particular case show facts that would have been outside the ordinary course of business, and then taking it that additional layer of actually bringing a fiduciary duty claim against your own member gives that second layer that removes it from the ordinary course of activities of Hunter Farms LLC, which was a single purpose entity.
Gave some objective things we can look at to determine whether or not it's ordinary course of business or activity. But subjectively, I want to know for sure, so the Syngenta payments has to do with one chunk of property, correct? 100 and so acres?
Syngenta payments actually deal with the historical acreage owned by the brothers back when they were a partnership, and then it was converted to a limited partnership, and then the development.
In a subjective way, what part of a pie does that represent of the Hunter Farms entire pie? I mean, are we talking like most of the pie, a sliver of the pie? Because that kind of helps me understand, is this a big deal for this kind of a business or not a big deal? For some families, it could be their everything.
Your Honor, from a larger perspective, these brothers did own 8,500 acres for 40 years. And they split it, divided their own way in the global settlement agreement. There's a 111-acre parcel in Grimes, which is the only parcel that's held by Hunter Farms. It's very valuable, not for its farming usage, but for its commercial resale. And so while the brothers have each taken their own share of the agricultural land, this is one remnant that remains.
Relevance does section 489-107 have here, which says the LLC Act is supplemented by traditional principles of law and equity?
I think we need to look at this specific statute, and it is helpful to look at what's surrounding the statute. But the key to this case is that the LLC statute does provide a right. So we have kind of the floor under the default rules that say there needs to be consent from all parties to do something outside the ordinary course of business. But the LLC statute provides a remedy. It provides a remedy through a direct action by a member, and it notably provides a remedy through derivative actions, which is the mechanism that can be used when the LLC is unable to obtain consent from all the members to take an action.
Only action that's really available when members of an LLC want to sue another member for violating their fiduciary duties under provision 409.
Members can enter an operating agreement, which can adjust and contract.
Under the default rules, at least.
there's derivative action, which I think is the key. I think that kind of pulls the pin from the majority's analysis in the Court of Appeals.
Case law that says when you have a claim involving a potential breach of fiduciary duty of loyalty, the voting member, the interested member, just can't participate. I mean, there's nothing in the code that excludes the application of that case law, and it seems like it kind of incorporates it because they have kind of disinterested member provisions on how you authorize those transactions.
It's our position that the language of all members is clear. And if you look to the derivative statute, as it's now been amended, they actually include the language of disinterested members in that through the formation of a special litigation committee. And so the legislature's inclusion of disinterested members in that provision and exclusion of that in 49407 is supportive of our position. So I see my time's expired. Thank you.
Mr. Babinat, did I pronounce that correctly?
Yes, Your Honor. I am proud to say I'm an alum of Waterloo East High and the Trojans, and as I was sitting here, I couldn't remember if our tune was to either the Notre Dame fights on or the Michigan one. Yes.
Thank you very much. You may begin.
Madam Chief Justice, Counsel, may it please the court. I think one thing that I would like to address at the onset is a bit of a clarification on the facts here in the record, because I know there is some confusion. Hunter 3 Farms and Hunter Farms are the same entity. Hunter Farms was converted into a limited partnership and then was subsequently converted into a limited liability company. It has the exact same EIN number as Hunter Farms. The title to this 111-acre parcel was never changed. And in fact, the global settlement agreement that we've been referencing here explicitly provides that anything that's not included, it has a catch-all provision, that any assets that aren't included explicitly within the global settlement agreement are property of what is now the LLC.
This Syngenta settlement, this is for the, I remember reading about it at the time. So this Syngenta settlement would be an asset of the old entity because that was the entity that was planting the seed at the time that the settlement covers. And now that title to that settlement proceed would have been inherited by the 103 Farms LLC. Is that right?
And to Justice McDonald's point, the submission of this claim by Mr. Hunter has caused a liability that the LLC must bear. With that said, I have 3 points I think that are important to the discussion here. The first of which hasn't been referenced at all, which is the standard on this case was for summary judgment, and we feel it hasn't been met. The second, of course, is what's been discussed at a significant length to date, which is that this is conduct within the ordinary course of activities. And then, of course, our last point would be the exceptional circumstances standard is consistent with principles of both law and equity, which are provided for within the statute. Very briefly on the standard for summary judgment, again, this case was dismissed on summary judgment where the district court found this was conduct outside of the ordinary course of activities. This would then infer that there's no dispute as to what is within the ordinary course of activities. But as counsel previously mentioned when he was up here, and as the district court explicitly stated, that's not clear as to what the ordinary course of activities are. In fact, the verbiage from the district court's order is there is little information to determine what is or is not within the scope of plaintiff's business. That alone, Your Honors, we believe would warrant a reversal and a remand. But if we go to the merits on that issue, we note, too, that the first step in this analysis is us needing to determine what is or is not within the ordinary course of activities. The majority from the Court of Appeals discusses the concept of ordinary course of activities, generally speaking, but it doesn't address whether this explicit conduct is within the ordinary course of activities.
Objective test, since it's talking about reasonable.
It would be an objective test.
This case, subjectively, it seems to me like it's probably not a big deal. It kind of could be ordinary course of business. Sounds like lots of, it's a big entity. But if we're looking at it objectively, one member suing another member, I'm just looking at it from a common sense perspective. That doesn't seem like ordinary course of business to me.
In that goes to an argument that we raised at the Iowa Court of Appeals that perhaps the fiduciary duties claims we would concede would be outside the ordinary course of activities. I could see problems as well, Justice Christensen, where you have members suing members. What we run into, though, is we're also dealing with a conversion claim and an unjust enrichment claim, which are what I would qualify as debt collection claims. And if we take that rule of a blanket rule in which Mr. Hunter advocates for, that any action involving a member, any lawsuit involving a member is immediately outside the ordinary course of activities, I can see problems arising. The example that I've been using, perhaps a little to exhaustion, is an example of a farm tenant. If Mr. Hunter was the farm tenant in this case, would we be barred from evicting him? Would we be barred from even serving a notice? After all, that is an action against another member. At some point, his membership status cannot morph what are otherwise ordinary course activities into extraordinary or outside the ordinary course.
I won't speak for Mr. Cady. I'm sure he'll make this argument, but I anticipate what they would say is that's not right because you could authorize a derivative suit, or you could bring a derivative suit, or at the beginning, from the outset in the operating agreement, you could put in a provision that says if one of the members happens to be the tenant, the LLC can go ahead and enforce its normal rights as it would against any other tenant. Right? I mean, it's not this huge intractable problem, I don't think.
Yes, these are issues where if you're creating an LLC, this is where the discussion of an operating agreement would be of use. And I don't practice corporate law, I don't prepare operating agreements, but I imagine that those practitioners look at the default rules for guidance on how to proceed. And if you look at the default rules, there's no real reason for us to think this is inappropriate.
It seemed kind of, incongruous to have a situation where the folks that own 2/3 of the LLC have to, instead of filing on behalf of the LLC to figure out how this money gets divided up, they have to sue their own LLC so that the LLC can then sue. That seems unduly complex, and usually the law doesn't favor unduly complex solutions, but that is an option, right? I mean, if this case, and if that happened, that would be an option, correct?
That it would be an option, not the only option. There's nothing in the statute explicitly that precludes bringing a direct action in this circumstance. What really this all hinges on is whether or not a lawsuit against a member as a matter of law in any capacity is automatically outside the ordinary course of activities. You could bring a derivative action, but then you have the additional burdens here of either bringing forth a demand, which in this case would seem a little silly because you're sending a demand against somebody who you know will not approve the lawsuit.
The exception for that, so that doesn't seem that onerous.
Correct, Your Honor, but that also can be litigated. In fact, I could easily envision a scenario where an individual would claim, well, you didn't ask me, so how are you going to know whether or not it's futile? And if we look at the standard that the state of Delaware has used now or adopted in 2021 for futility, they just look at essentially a disinterested member standard as well. The only practical implications that I really envision here are these issues of resource allocations. And this is an issue that Mr. Hunter raised in his brief, which is, hey, the LLC can prosecute me and therefore use the LLC's resources against me, and I don't have the ability to monitor. But those issues essentially give rise essentially to either a dissolution action via oppression, or the other members have their own fiduciary duties they need to bring forth. To go back to the ordinary course of activities analysis, I think that's where this all rests here. And we know from the majority, they don't discuss whether or not this is inside the ordinary course of activities. And the dissent at the Court of Appeals assumes without explanation that this is outside the ordinary course of activities, largely adopting the approach Mr. Hunter has advocated for. There's no support for this particular position within the statute itself. The statute provides that ordinary course activities require a majority and anything outside require unanimity. And we've discussed those two, I call them two classes of actions that are outside the ordinary course of activities, which are either a change in disposition of all or substantially all of the property or an internal governance issue. To your point earlier, Justice McDonald, excuse me, if there was a situation where a member became a farm tenant after the formation of the LLC, you would need unanimity amongst all of the members to modify the operating agreement. That'd be an example where unanimity would be required.
Why wouldn't a lawsuit against a member be, trigger the, or fall within an internal governance issue?
I think that's where we go to the fact-intensive nature of a ordinary course of activities analysis. And that's outlined both in the majority. They cite the CJS provision that discusses the fact-intensive nature of that analysis. And it largely depends, Justice Waterman. Some cases and some corporations, debt collection, would be routine, and it just happens to be a member in this case. We would take the position that, if we're going to use the baseline rule, this is a farming operation, the Iowa legislature has essentially recognized that farming and debt go hand in hand. There's 7 ag lien statutes at issue. The district court itself
Receiving payments, not usually from seed companies, usually you're sending them money, but you receive payments from the government, for example, that's fairly common. That would be within the ordinary course of business. So if one member took more of, some payment that, flood insurance or they had some CRP land or something like that, and one took more than the other, that might be something that would happen fairly often.
I mean, that is exactly what happened in this case here, or at least that's what's being alleged, is this is debt. The Syngenta claim arose from the use of Syngenta products during the ordinary farming operation. So submission of that claim is precisely what you're describing, Justice Mansfield.
All the proceeds just to go to one?
Well, proper corporate governance would say that if the LLC submits a claim, the money should go through the LLC first, and then you distribute it amongst the members. We don't have anything in the record as to whether or not that's how they would typically do anything, because again, we know the record is pretty, as the majority notes and the district court notes, there's not a whole lot of a record here as far as what is ordinary course of activities.
Issue of whether or not something is within or outside of a regular course of activities is fact intensive. How general or how specific should we look at that question?
I've been relying on the CJS definition just because I feel that's the most thorough. And that explicitly states that you not only look at the transaction, I envision it as looking both retrospectively at the conduct of the company, but also prospectively at potential conduct that it may incur. Because the CJS definition looks not only at the conduct in which the company itself has done, but also then conduct of similar companies in similar industries. So I guess to answer your question, Justice Oxley, it would probably be a little bit broader than the more narrow approach advocated by my colleague here, where you look solely at the activities of the LLC in question. I would like to briefly touch, just because I know my time is running short here, on this disinterested member exceptional circumstances standard advocated by or adopted by the Iowa Court of Appeals. If this court feels that this specific action is outside the ordinary course of activities for Hunter 3 Farms, then we do believe that the exceptional circumstances standard is appropriate. We feel that the statute is ambiguous. You cannot look purely at 489.407 and have a clear understanding as to what ordinary course of activities means. It's not a defined term in the statute, and as evident here, there is a good faith difference as to what it could entail.
Relied on some partnership cases, and generally partnerships don't have derivative actions. Does the fact that the LLC statute allows a derivative action make those cases in a posit here?
I don't necessarily think they make them an opposite. I think they make them a bit more distinguishable. Because you still run into the same practical issue here that you would with a partnership. I know that the derivative statute provides an out remedy for a shareholder to seek a recourse against the management of the company. Shareholders are not necessarily always going to be members or directors of a company.
The LLC statute doesn't talk in terms of shareholders. It's the LLC statute itself has its own derivative action.
Correct, but it provides, it's an elective option for a member to pursue. That's what I was getting at, Justice Oxley, is that the LLC statute is a bit of an oddity in that both the manager-managed governance and the member-managed governance both provide that unanimity is required by the members for extraordinary circumstances. So there's a clear analogy between the corporate statute and the corporation statute and a manager-managed LLC because you run into that same problem. It becomes a little bit more muddied when you have a member-managed LLC because typically a manager could pursue a claim on behalf of the LLC without any issue, but are the members able to do so without when there's opposition by one individual member? That becomes a little less clear.
The derivative action, the LLC statute expressly allows a derivative action that kind of takes you don't need to go through that, all of that. You can just go straight to a derivative action.
The difference is a burden of proof issue. For a derivative action, I see my time is expired.
Sir.
I view this more as a difference of burden of proof. If you bring a direct action on behalf of a LLC, the question isn't whether or not there's futility or the procedural requirement of a demand. You essentially have to prove that this conduct, either if you adopt the Iowa Court of Appeals standard, is an exceptional circumstance, or the more moderate position we would advocate for, which is this is within the ordinary course of activity. You have to show that degree of authority as a threshold question. Compared to a derivative action where you have to either plead that there was a demand made or you have to have the procedural fight over futility. Either way, there's going to be a question. I view that the standard being a little bit more favorable in a situation where you have a majority running the LLC because there really isn't a huge issue of authority so long as it's within the ordinary course of activities. And for those reasons, Your Honors, we believe that the court should affirm the Iowa Court of Appeals rule. Thank you.
Thank you. Mr. Cady.
I want to just jump back just for a minute with the ordinary course of activities point, because this is not a case about the entitlement of the LLC to the Syngenta payout. It's not a dispute with Syngenta itself. What this is it's a dispute with a member, members who have butted heads and disputed multiple issues over the last few years. And it's a dispute with that member over a breach of that member's alleged fiduciary duties, an alleged breach by that member of its duty of good faith and fair dealing. As counsel conceded, fiduciary duty claims are outside the ordinary course of a company's activities. And it's our position in this case that this one is well outside of the ordinary course.
Are you saying in a way, Mr. Cady, that they kind of pled their way into this problem because they probably could have pled kind of turned down the volume a little bit in their petition and just pled sort of some kind of accounting or breach of a contract or something like that would have sounded more in the ordinary course of activities? Is that what you're saying?
The facts of the Syngenta settlement payout could be, construed to be part of the ordinary course of business. If they had a dispute with Syngenta or about what acres are included in that in the LLC, but this is
a conversion claim apart from the breach of fiduciary duty, and would the conversion claim be a better fit within the ordinary course?
Did, Your Honor, there's conversion and unjust enrichment, and those were in addition to the fiduciary duty and breach of duty of good faith and fair dealing. And each of those claims arises out of the same conduct of Richard as a member and his actions and what he did to not apply for this payout for the LLC.
This work in practice? I mean, under your rule, you have a 3-person company. Let's say they take a vote on whether or not they should authorize a suit against Richard. I assume he's voting no, right?
I would assume so, but we don't.
Even under the code? What about the rules that prohibit him from participating in company activities when there's an adverse or potentially adverse claim against the company?
Under Section 49, 407, all members would have equal rights, and he would have the right to participate in this decision. He did not participate in this decision. There was
89, 409 that says a member who has an interest adverse to the company can't participate in those decisions. So I'm not even sure he's allowed to vote under the code.
I'm not sure that exact application under 49, 407 in that context, but the facts are that he was not asked to vote and did not vote in this. And the case is that under this provision, if this court is to find it's an ordinary activity, it would require all members. The legislature knew how to include the provision of disinterested members. It has in other contexts, including in this particular LLC Act, and chose not to do so. And before I wrap up, I just want to add some complexities that if the Court of Appeals decision is affirmed, that would create. And as I've emphasized, this is supposed to be a default rule, a backstop for LLCs and for members. And having this exceptionality requirement and having a disinterested member requirement, all it does is create ambiguity in what's supposed to be a stable and clear fallback. The example is, who qualifies as a disinterested member? And this might get back to that point. What if it was Gary and Richard who had applied for the Syngenta settlement proceeds and they deposited it in their own bank accounts, and it's Richard who believes that it was the LLC's property? Would Richard therefore be the only disinterested member? And would Richard be able to file a lawsuit against his brothers because they would be interested in this case? Under the Court of Appeals decision, the answer would be yes, that he would be. And so what's meant to be a model of stability and clarity as the baseline for LLCs, in this case, if the Court of Appeals opinion is affirmed, would create nothing but confusion and ambiguity. So with that, my time has expired, and we respectfully request that the decision of the Court of Appeals be reversed. Thank you.
The case of Hunter 3 Farms versus Richard Hunter is hereby submitted, and the court is adjourned for the morning.